This is Michael Popok, Legal AF. Jack Smith took a lot of flack for where he filed the criminal prosecution against Donald Trump for Mar-a-Lago, the venue as required by our U.S. Constitution. He chose Florida, the situs of Mar-a-Lago, where the obstruction and the Espionage Act, at least, not even arguably, can be said to have been committed, which complies with the Sixth Amendment right to a fair trial, a fair and impartial jury in the district in which the crime is committed. But everybody was up in arms. Why did he file in Florida and get that shortest of shortlist assignments by Judge Cannon? We don't like Judge Cannon. The case should be in District of Columbia. We like Judge Chutkan and judges like her. Why did he do it? Well, we now know the reason, because he had a legitimate fear based on a Supreme Court decision that came down in June and a new decision that just came out of the Ninth Circuit in California, that if he filed in the wrong venue, it would give grounds to Donald Trump to vacate and overturn his conviction and have the case retried all over again a year later in front of an entirely new jury with potentially different results. Let me piece it all together here and explain it to you on this particular hot take. What am I talking about? Keep two things in mind, or three things in mind. Jeff Fortenberry, a Nebraska former congressperson of the 1st District, got tried for lying to FBI agents and violating 18 U.S.C. 1001. He got tried not in Nebraska, where he gave one of the interviews to the FBI, not in D.C., where he gave another of the interviews to the FBI, but in Los Angeles, because that's where the FBI agents were seated and where the investigation was based. And the Ninth Circuit, mindful of a recent decision by the U.S. Supreme Court, a case called Smith, which just came down in June of this past summer, in that Smith case, which is now binding precedent, United States Supreme Court precedent, the United States Supreme Court said that if a defendant, criminal defendant, is tried in the wrong venue in violation of the Sixth Amendment, which requires that the jury be picked from the jurisdiction and the district in which the crime is committed, that the remedy for that is not the guy walks scot-free and can't be tried again because of double jeopardy. It's that he gets an entirely new trial, his conviction is vacated, and you got to do it all over again, probably a year later, in front of an entirely new jury, and wait and see what the results are. Just because one jury convicted the person doesn't mean another jury is going to do it. So you got to do it all over again. And that is what we said originally on Legal AF, how smart Jack Smith was to avoid the problem in the Smith Supreme Court decision, that if he tried it in the wrong place, and there was an argument that you could try it in the District of Columbia, the Mar-a-Lago case, and I'll explain that in a minute. But if he got that major venue decision, Sixth Amendment constitutional decision wrong, the penalty for that is that he'd have to try the case all over again, which means that if Jack Smith's ultimate goal was to try a case against Donald Trump before the election in November, in order to have the American people make the decision at the voting box about whether they wanted this convicted criminal or somebody who's been absolved of a crime being president, if that was Jack Smith's goal, it would have been scuttled by filing it, the Mar-a-Lago case, in the wrong jurisdiction and having to start all over again and go back to square one because he wouldn't have enough time, right? He'd get the conviction in May or June. He'd have to go back and try a new case 3, 6, or 9 months later in the right jurisdiction and go through a whole process with an entirely new judge, right? With all of the procedures and rules. Yes, some of it would carry along with the trial, but all bets are off. New judge, new rules, new motion practice. That case could be tried a year and a half later. That was what the dystopian, apocalyptic world that Jack Smith was trying to avoid. And we patted him on the back on that in Legal AF. Back in June, when the Smith decision at the Supreme Court level came out, we said that is what he was trying to avoid. We're all smacking our forehead. He had a grand jury in the District of Columbia that was issuing search warrants and subpoenas that was being managed by, at the time, Chief Judge Beryl Howell. He had another one in Miami, in South Florida, doing the same thing. But then when it came time to file the indictment, he did it in Southern District of Florida. It got assigned to Fort Pierce up in the upper hinterland of the Southern District of Florida, because Mar-a-Lago sits in the Southern District of Florida in Palm Beach, Florida. And so we gave him credit where credit was due. But now we see the beauty of it, the genius of it, of what he was trying to avoid, the buzzsaw to cut his case in half or cut it down completely. Because just this week, just today, the Ninth Circuit Court of Appeals, applying the teachings of the Smith decision, has ruled that at least for a 1001 criminal charge of lying to an FBI agent or lying to a government official, which is sort of part of the indictment against Donald Trump and Mar-a-Lago, but not exactly, that particular crime can only be committed where the false statement is given. And Fortenberry gave a series of false statements, but only in two locations: in his office in Congress in D.C. and in Nebraska, where he's from, never in Los Angeles. And so they found in the Ninth Circuit, in applying the Smith precedent, that for at least for this type of crime, the situs of the crime, right, the locus delicti, as they like to say in Latin, the location or site of the crime, is where the false statements are given. And so it could never be Los Angeles. And so applying Smith, they vacated the jury verdict against Fortenberry because he lost, and they are applying the remedy, which is sending it back to be retried in a proper district of the prosecutor's choice, either District of Columbia or Nebraska, but start all over again with a new judge and a new jury and a year from now. And so that is the result of what happens when you have a prosecution that happens after the Smith decision in the wrong venue, or arguably the wrong venue, because you have to focus on that Sixth Amendment right, not just to a fair and impartial jury, which is the way we shorthand it, but to a fair and impartial jury in the district at which the crime is committed. Now, there is one bit of analysis from the decision that I think it's worth applying here, because they anticipated, the Ninth Circuit Court of Appeals, or at least the three-judge panel here, and Judge Donato writing for the panel there, they said it may be a different set of analysis for the site of the crime, for venue analysis, for Sixth Amendment constitutional principles, if we're talking about obstruction of justice. And at the heart of the Mar-a-Lago case is obstruction of justice against Donald Trump. Yes, Espionage Act and obstruction of justice related to the presidential records and the national defense information documents that have been retained, right? Those confidential information that's been stolen, obstructed by, attempted to be destroyed by Donald Trump. Now, there, they say that you may have to look beyond where the action takes place to the effect of the action, where it impacts. And I can make the argument, and I'm sure you can too, that District of Columbia is where the documents were stolen from, where they were hidden by Donald Trump, that those are presidential records, that District of Columbia is the proper place for this, that Donald Trump, in his obstruction of the National Archive, sitting in D.C., is an obstruction in D.C., his willful interference, as alleged in the indictment, with the investigation of the FBI and the Department of Justice in D.C., interfering with the subpoena and the search warrant that emanated from a D.C. grand jury, means that an alternate proper venue for the Mar-a-Lago case is in the District of Columbia. In fact, the Ninth Circuit panel goes as far as to say the following, that if it's dealing with obstruction of justice, then you might be able to apply the effects of where the effects of the obstruction are felt in your analysis. They just weren't going to use that doctrine when it comes to false statement. There, they made the law, which until the Supreme Court says otherwise, is the law of the land, that a 1001 violation has to take place and has to be charged and tried where the statements were made. Pick your poison, Nebraska or District of Columbia, Department of Justice, and not in Los Angeles. But that's not the case for obstruction. So I just laid out, even under the teachings of this new case involving Fortenberry, Jeff Fortenberry, I still think there was an argument to be made, and probably a good one, that there was more than one venue that was proper under the Sixth Amendment for Donald Trump to be tried. But you know that if Jack Smith brought the case and filed it in District of Columbia, that eventually Donald Trump would get around to arguing that venue was improper under the Sixth Amendment to have it dismissed. And if he waited till a late in the game, that issue would take months and eat months of the clock, making it virtually impossible to have the case tried in March May as it's being tried now, at least we think, in Florida. It would have been May plus 6 months, well after, if your target, your radioactive red letter date is March the 4th for the trial, or May in this case for Mar-a-Lago, and you want to stay on the March-May timetable for Donald Trump to have at least one, if not two, trials and possible convictions before November, well, then you don't monkey around with venue. You don't give Donald Trump the ability, because if you indict him and bring the case in Florida, where Mar-a-Lago is located and where the search warrant and the subpoenas were executed, he has no argument about venue. But if you bring it somewhere else, you've opened the door to at least a discussion at the appellate level, at several appellate levels, and the time wasting related to that about whether venue was proper in the District of Columbia as well. It's an interesting academic exercise, but if you're a prosecutor trying to bring somebody to justice and have the public understand whether they're voting for a criminal or not before November, then you don't want to monkey around with venue and whether you violated the Sixth Amendment, especially when you see the decision in the Smith decision in the Supreme Court in June, which says that the remedy for screwing it up on venue is you got to try the case all over again. New judge, new jury. And now we're seeing exactly that in Smith being applied in the Fortenberry case in the Ninth Circuit. So for those that said, oh, it's unlikely that would happen. Really? Fortenberry's entire conviction was just thrown out, and he's going to have to be retried again sometime in 2024, I presume. If he doesn't cut a deal now and a plea deal, because he's got some advantage to having won, that's what just happened. We just saw a real, this boomerang. We just saw it in action. Smith decision in June. Fortenberry getting sprung, if you will, in December. Same year. And that is exactly, right, what we just saw. That is the buzzsaw that Jack Smith tried to avoid and did successfully avoid, even though we don't like the judge that he got. There was about 3 other judges that were better than Aileen Cannon that could have been selected by the random wheel, or at least one other judge. Could have been Judge Middlebrooks, frankly. That's about it. But he took the risk to avoid the venue possible appeal and dismissal and having to start all over again from square one. So we'll continue to follow and explain why Jack Smith does what he does. Nothing's done by accident. People that thought, oh, he made a tactical error. No, he didn't. He made a strategic, proper decision about where to file to avoid a venue dispute and have the case thrown away later or give Donald Trump or strengthen his hand on appeal. That's what we observed. And we did it on Legal AF at the intersection of law, politics, and justice. And we do it every Wednesday and Saturday on the Legal AF podcast. I do it with Karen Friedman Agnifilo, Ben Meiselas, and then on hot takes like this one about every hour at that same intersection. If you like what I'm doing, give me a thumbs up, leave a comment, helps keep me on the air. And then you can follow me on all things social media at MS Popok. Help the MeidasTouch Network reach 2 million free subscribers. Thumbs up and a free subscription will help. They're oh so close to 2 million. So until my next hot take and until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.